Okay. Well, welcome to the Flipping and Wholesaling Houses in New York show. I'm Michael Pinter, where I teach you how to start flipping and wholesaling houses, or if you're already doing it, how to grow your business. You see, there's a big circle going around, and all right, I think it started. Whatever. I hope it did. If not, welcome to the Flipping and Wholesaling Houses in New York show. So, we're talking about are double closings illegal? So, we're going to talk about what a double closing is, why you may or may not want to do one, and then we're going to talk about are they legal, and at the end, I'm going to tell you why there's something that I rarely do in New York. Okay, so a double closing means that you are going to basically buy and sell a property on the same day, right? So you're in contract at something at a discount, you find another buyer for it, and you want to buy and sell it. So it's a very popular term that's used in a lot of other states, and here are the basic reasons why. In a lot of other states, it's very easy to get into contract, right? You meet a seller wants to sell, you say, I want to buy, price is X, seller says, okay, bring them a contract, and you're in contract. But it's very easy for that seller to get out of the contract because the contracts are basically bullshit. You don't have a lot of legal recourse to get someone who signs a contract to actually perform by that contract. Same for a buyer, really. If you're selling something and a buyer says it wants to buy, gives you a minuscule deposit in the other states, $100, $50. If he doesn't want to buy, you're pretty much done. So it's very, 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 very different in New York. Now, just as an aside, there are people will tell you, well, there are ways to protect yourself, and there are. In certain states, you can record the contract, you can record a memorandum of contract, you can record an affidavit of contract. Those are nice, but they don't really force the other party to perform. They just make it difficult if a seller doesn't want to sell and you have something on title that said you were in contract. Theoretically, if he uses certain title companies, they could come back to you and say, hey, how much is it going to cost to get rid of this? But it doesn't really force them to perform. One of the greatest things about New York, and there are a lot of difficult things about New York, well, it's really two sides of the same coin. One of the most difficult things about New York is it's very hard to get into contract, right? When the seller says yes to me, I'm looking now, I have 2, 4, 6, 8, 10 properties where a seller said yes to me, they're not in contract yet. I need a seller to engage an attorney and draw up a contract to send to my attorney. That is a pain in the ass process. And one out of 100 maybe deals that fall apart in that process. Most don't. So the story is that once you're in contract in New York, you cannot get out of contract. So if a seller says to you, hey, I changed my mind. I heard I can get more money. In general, I just laugh it off and I say, speak to your attorney, which always results in them saying, when can we close? Because in New York, if you're a buyer in contract and a seller doesn't want to sell it to you, you can do two things. The first thing you can do is actually file a list pendants against the property, which is the same as if they're in foreclosure from their mortgage lender. So they will never ever sell that property to anybody else. Second thing you can do is sue the seller for specific performance, which means the entire purchase price. And you will win. And because sellers are represented by attorneys 99.9% of the time, the seller's attorney is going to tell them that. You really have no options. You have to close. So you don't have a problem. Now, the reason why people double close, I think I'm getting ahead of myself, is because they're afraid that when they get to a closing and they're assigning a contract and they're buying it for $150,000 and selling it for $200,000, that either the seller's going to get pissed off that they left money on the table or the buyer's going to get pissed off that they are buying something that's too expensive, paying too much money. And they're afraid somebody's going to walk from the closing. In New York, nobody's walking from the closing, ever. So you don't really need to double close if that's your goal. So I remember one of my first wholesale deals was over six-figure deal, $120,000. I still remember. I don't remember the address. I know it was in Great Neck. And it was an angry guy who was constantly yelling at me about how he's getting taken advantage of. And I asked my attorney, I'm scared. Should we double close this? Because I'm afraid this guy's going to walk. And he's like, listen, the guy might be pissed off, but he's got to sell it to you. Those are great words that I heard. And it's the truth. And I didn't go to the closings. I don't go to closings. But we made the money on it. So you don't have to worry about a seller or a buyer getting pissed off because they don't have any other options. Now, could be other reasons why you would double close. Now, I had a situation once where I was buying 7 properties from someone. I didn't really want to buy 2 of them. I sort of restructured the price on 5 of them, and I didn't want to get into the other 2. So I double closed on those 5. It was expensive. Now, in New York, double closing is really expensive because transfer tax is large. Title companies are going to charge you a lot of fees. Recording fees are crazy. You have to record an extra deed. That seems like a so stupid thing. That could be like $800 in Nassau County. Legal charges. If you have to fund it, right, with transactional funding, which means a lender that's going to lend it to you for a day, you can pay 1 or 2% on it. It gets expensive. And that, in fact, that deal cost me, it was 5 deals. It cost me about 40 grand. So it was $8,000 per deal. And they were big deals, but it was probably one of my best deals ever. And I felt like I needed to double close. The truth is, I may not have even needed to it. So, question is all this legal? And the answer is 100% absolutely 1,000,000% legal. There's nothing wrong with it at all. You're simply transacting things. Nothing's being done that's illegal, right? The issue is, can you? This can be done with certain title companies in other states will allow it. It's never going to happen in New York, right? Now, just to understand, in 49 states, the title company manages the transaction. They disperse the funds. They really are everything in a transaction. In New York, title company is just a service provider. They're there to do two things: make sure the liens are paid off, make sure the taxes are paid off. They are not dispersing funds except to pay taxes or pay off liens. But the money that's going from the buyer to the seller is being transacted through an attorney in New York. And what people do with a double closing sometimes is they will sell the property before they buy it. So the title company will allow that to happen, maybe simultaneously. Maybe they'll have the buyer in one conference room and the seller in another one. In New York, you can't use the buyer's money for the seller's proceeds. You can't do that, right? Because it's using escrow funds, and if anything would happen, if there'd be a hurricane, a tornado, and the attorney would get stuck in the middle, the attorney could get disbarred for using funds that are improperly. So you can't do that. So if you're doing something like that, I'm not going to say it's illegal if you're using a title company in another state and they're okay with it. I'm not saying it's illegal, but in New York you probably can't do that. So I think what's important here is there's nothing illegal about buying something and selling it simultaneously. But the funds you have to be on top of it. And in New York, there's a much bigger difficulty because the attorney is dispersing it and they're not going to do what a lot of people want to do. So if your point of a double closing is so that the parties don't leave the transaction, you don't need to do that in New York. If your purpose is to use the buyer's funds for the seller, then you really got to talk to the closing agent and see if he'll do that. I don't know any attorney that'll do that in New York. I think it's a mistake, even though it's a 1 in a million chance that the buy won't happen after the sell. That chance is enough, I think, for most attorneys not to take it because it's the risk is very high. Not the risk. The risk is very low, but the penalty for screwing that up is very high. So they're definitely not illegal at all. No, in no way, shape, or form. The question is really, what are you trying to accomplish with it? So in New York, I usually just assign the contract for the reasons we discussed. It saves me money. I don't have to pay closing costs, right? In New York, it's exorbitantly expensive to double close. And it's unnecessary to double close because all the parties that are signed up, your seller to you and the buyer from you, are not going anywhere, regardless of even if you're making $1 million as an assignment fee. It's irrelevant. They cannot leave. The same protections you have on the seller side, you have on the buyer. If a buyer walks, you can sue him for specific performance too. Actually, no, you can't. You can't sue him for specific performance. You can keep his deposit, but it's a big difference. In New York, you're going to take a pretty significant deposit, right? In New York, standard deposits are 10%. It doesn't have to be 10%, but usually I'll take 5%. So if I'm buying something for $300,000, I might give $15,000. I might take $15,000 or $20,000 from the buyer. So they're not going to walk away from that. That's another reason why people don't walk away from deals in New York, because the deposits are significant. So I would say you don't have the need to do it in New York because all the parties are pretty much obligated to close, and you don't have it's cost prohibitive in many cases because it's going to be expensive, right? Between transfer tax, recording fees, like I said, it cost me $8,000 a deal. It was 5 houses. It cost me $40,000 a double close. It was a big deal. I made a lot of money on it, but it really is not something not something you really need to do or something you want to do in New York because it's not necessary to keep the parties honest, and it's cost prohibitive if you do it. But it's perfectly 1,000% legal unless you're selling a property that you don't own before you buy it. That's where it's a little shady, and speak to your local legal professional about whether you can do that or not. So I hope this was helpful. If you want all the different ways I can help you, go to howtoflipnewyork.com. If you're interested in my course that teaches how to do what I do, go to howtoflipnewyorkcourse.com. If you're interested in one-on-one coaching from me, go to coaching.howtoflipnewyork.com. What else? Oh, if you're watching on YouTube, please subscribe. Whatever platform you're watching on, please give me a thumbs up. The likes really help me. Got a lot of more people watching my videos now, so that is very, very good. And if you have a so please keep the comments coming. I go live 5 times a week. I don't always know what the hell I'm going to talk about. If it's there's no bad comments. If it's a simple comment, I will respond. If it's a topic, hello, Mr. King. If it's a topic that I've covered recently or in depth, I'll send you links to the videos. And if it's something I haven't covered recently, I will do a video on it. So thank you very, very much for watching. And I will send my phone number right now, which I think is posted every time. And I just sent that. Thank you very, very much for watching.